Hello and welcome to episode 95 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh DeHaas, counsel with the Canadian Constitution Foundation.
And I'm Christine Van Geyn, the CCF's litigation director.
I'm Joanna Baron, CCF's executive director, and in today's episode, I'll share my thoughts on the Hockey Canada sexual assault trial verdict.
And I'll tell you about my new paper on why bubble zones are such a bad idea.
Plus, we'll share a bad legal takes of the week where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to discuss the debanking of Alberta lawyer Eva Chipiuk and whether we should be paying more attention to the Liberals' proposed cash ban. So Eva Chipiuk is a lawyer who represented some members of the Ottawa Freedom Convoy at the Emergencies Act Commission. She famously cross-examined the Prime Minister. And this week, she broke the news that RBC is dropping her or has dropped her as a customer. And a lot of people immediately assume that this is because of her right-wing politics or who she represents in court. And I can see why some people would think that, considering what happened during the Freedom Convoy, where the government used the Emergencies Act to shut down the bank accounts of their political opponents, famously freezing 200 plus accounts. But so far, we see no evidence that that's actually what's happening to Chipiuk here. In fact, it seems pretty clear that it was something else that actually led to her debanking, although that too is concerning, and that's what we're going to talk about today. So we've talked about debanking on the podcast before. This is just where a bank drops their customer, and it can be concerning since we all need access to banking, and sometimes it appears that they're doing this for political reasons. In Chipiuk's case, she told the Financial Post that she was debanked after she sent two e-transfers 2 days in a row, each for $1,000 to a company called ShakePay, which facilitates buying and selling crypto coins. And after the second transfer, her account was frozen, and she was forced to go into a branch to try and get her accounts unlocked. But they didn't get restored, at least not for very long. Chipiuk actually recorded her conversation with the bank, and they basically interrogated her all about her cryptocurrency transactions. So the employee there asked her a bunch of questions. He asked, how did you learn about this opportunity with crypto? Is there a third party involved? Do you have full access to your own crypto wallet? How long have you been investing in crypto? To which she answered that she'd been doing it a long time. And the letter stated that this letter debanking her, stated that after careful consideration, we regretfully advise you that the recent activity in your accounts is outside of RBC's client risk appetite. Consequently, we are no longer in a position to continue our banking relationship with you. And they didn't say why she's no longer outside of their so-called risk appetite, and there's no apparent way to fight it. So she's now signed up with a credit union instead. So Chipiuk posted this letter online, and the interesting thing is that it prompted thousands of comments with at least several people I saw saying that they got really similar letters from their banks, not just RBC, but also CIBC and Scotiabank. And in most of, if not all of these cases, the Twitter users reported that they were debanked after crypto transactions. So we don't really know how common this is. We know the Ombudsman for Banking Services and Investments said they received 94 complaints last year related to debanking and 105 the year before. But obviously most people who are debanked aren't going to complain to some, third-party ombudsman. So we don't know how often this is happening, but it's probably hundreds, if not thousands of people per year in Canada. I talked to a friend who is an expert in crypto law, and he said that this may be because the banks suspect the crypto is being used for illegal activity like money laundering, and they don't want to face fines from regulators for allowing money laundering in their banks, which would be understandable. Then again, this is Eva Chipiuk, who has a pretty sterling reputation, so I think it's pretty scary that someone like this can just suddenly lose access to banking. And people have asked also, is there a constitutional aspect to being debanked? And it's a bit tricky because yes, it's a private bank. So if they're doing it on their own accord, the charter wouldn't come into play. But if the government does something like they did during the Freedom Convoy, where they force banks to freeze accounts of customers or dump customers, then it would potentially be a charter issue. But either way, it's a big deal to be debanked. Think about it. If in the future your bank debanks you, and then the other, five of the big six banks also debank you, you might not be able to get a mortgage or have a debit card or a credit card or pay your bills. You get effectively frozen out of society, like the trucker convoy people who had their bank accounts frozen were for a period of time. And also, this is reminiscent of what's happening in China with Chinese social credit, where you can get put on a blacklist for any number of infractions, including, so-called political crimes. I remember writing about this before, and one of the examples was a lawyer who was blacklisted because their clients weren't paying certain fines. And you just end up completely sort of frozen out of society if you get fully debanked. And as regular listeners know, the Liberals' so-called strong border bills would make it illegal for any person or entity engaged in business, a profession, or the solicitation of charitable financial donations from the public to accept cash payments in excess of $10,000 in a single transaction or a series of transactions. And so in the future, it'll be illegal for most reasons to use $10,000 more of cash. So what if you've been unfairly debanked and you can't find a credit union to take on your banking and you have to start using cash? Well, that'll be soon essentially illegal. So people might turn to crypto, but what if crypto gets regulated and governments find ways to shut down crypto for, political reasons? It's all a bit concerning. So even though I doubt that, Ava, pardon me, was debanked for political reasons, like some suspect, I do think this is a bit of a warning shot for us. Joanna, what about you? Are you worried about this $10,000 cash ban or about debanking regulations in the future?
Yeah, I think first of all, the $10,000 cash ban seems fairly arbitrary. And I think we should be concerned about debanking, whether it's happening for crypto skepticism, political reasons, or something else entirely. I think it's obvious that financial access is a prerequisite for participation in society. And when banks start cutting individuals off with no transparency and no recourse, that just raises red flags about privatization of punishment, due process. I actually have a little brush with this myself in a way, but it was freaky enough. This was like maybe close to 10 years ago. And some of I used to do it kind of more often. Now I'm so focused on the creep in civil liberties in Canada, but I kind of teach yoga on the side. And at some point, I had a Stripe account for taking payments for workshops and stuff like that. And the Stripe account it wasn't under Joanna Baron. It was under maybe like JB Yoga or something like that, which like I wouldn't have thought was a big deal. But my Stripe account was connected to my Tangerine account. And so it was set up so that the Stripe payments would be deposited into my bank account. And one day, I tried to log into my bank account and completely blocked. We're sorry, you can't access your accounts. You can call us for more information. So I called, and at first they were like, oh, we can't tell you. And it's like, this is my bank account. Like my, mortgage payments come out. Like, what the hell do you mean you can't tell me? So keep pushing, keep pushing. And finally it comes out that because the Stripe transfers, and mind you, these transfers for like $20, we're going from JB Yoga. It was flagged as possibly fraudulent, like FYI, to any small business owners, your bank account and your Stripe account have to be under the same name. I guess it's like a check has to be written out to your name. But it was terrifying. And as soon as, I changed it around and explained it, they lifted it. At least in that case, it was a specific thing. But I can imagine where it's more of a sensitive matter where they'll just tell you nothing. And it's really terrifying. So I don't know. Anything to add, Christine?
I think it just shows the dangers associated with having this oligopoly in all kinds of industries in Canada. Like the fact that we have the six banks, the fact that we have really limited telecom providers, that if one of these companies decides to cut you out, you have very limited choice in alternatives. And it's because Canada is just not a competitive environment. We just don't have enough competition within industry. And attempts to sort of break up or have more competition have not been successful in Canada. And I mean, at least there are these credit unions that EVA could go and use to have some sort of recourse, but they can't provide all of the services that these large banks can. So I just think people need to. We talk all the time about, as Canadians, about the problem of having these oligopolies, and this is kind of demonstrates the risk associated with it. Let me turn now to my news headline, which is about a new paper that I just had published by the MacDonald-Laurier Institute. It's called Burst the Bubble: Anti-Free Speech Bubble Laws Are Unconstitutional and Expanding. We Need to Stop Them. So in this paper, I talk about the origin of these bubble laws, their evolution, justifications, and the constitutional problems with them. So I encourage everyone to go over to the MacDonald-Laurier Institute's website and check out the paper. I'll briefly tell you a little bit about it here. So in terms of the origin of the laws, these bubble zone laws were first introduced in the 90s to address blockades near abortion clinics, as well as at the same time there had been an attempted murder of an abortion providing physicians, I think two abortion providing physicians. But now bubble zone laws restrict wide range of protests, from protests about gender ideology to foreign policy, and they are now applying to thousands of locations across Canada. And these laws limit where and how individuals can express political views, often targeting speech based on its content. And, these laws are always framed by the government as measures to protect, quote, safety or access or to protect the value of inclusion, but they operate by suppressing uncomfortable or unpopular ideas in public spaces. And these are precisely the types of ideas that freedom of expression exists to protect. I mean, the right has no meaning when it only protects uncontroversial speech that everyone agrees with. It only really has meaning when you get to the edges of speech that makes people uncomfortable. So governments, as I said, they justify these laws by claiming they create a safe space around sensitive institutions like hospitals, schools, places of worship, libraries, daycare centers, but they actually go way beyond preventing violence or maintaining access because violence is already illegal. Blockades are already illegal as well. They actually criminalize peaceful protests, and they are aimed at prohibiting emotional discomfort. Which you don't have a right to emotional comfort. The case law is very clear that freedom of expression includes expression that makes people upset, offended, emotionally unhappy. They the location of the protest often is what gives the protest its meaning. So by excluding these sensitive places like a school, it actually removes the meaning of the protest. Like a labor strike would have no meaning at all if you had to have your labor strike not in front of the employer, but down the street at a park. It would have a completely different meaning, just as a protest about a government policy would have less meaning if it wasn't in front of a government building. A school policy would have less meaning if it wasn't in front of a school. A protest about a particular speaker invited to a church or a singer, if we're going to talk about the current controversy. If you had to protest Sean Foyt down the road instead of in front of the church where he's performing, that protest would have much less meaning, and it dilutes the effectiveness of the message, and it actually violates the Charter's guarantee of free expression, which is a content neutral guarantee and protects expression even when it's offensive. Now, the history of these bubble zone laws was, originally the abortion ones was a response to real violence like arson and shootings at abortion clinics, which I will say was already illegal. They could have used existing criminal law, even in the 90s. But in any event, the tactics of the 90s has largely now been replaced by peaceful expressions at these abortion clinics, picketing, leafleting, prayer vigils. But even though these laws were no longer really even necessary at these abortion clinics because those more controversial tactics or any illegal tactics had ended, the governments across Canada actually started expanding bubble zone laws, citing the need for emotional and psychological safety, which is this vague and subjective standard that's actually incompatible with constitutional rights. And that shift really accelerated during the COVID pandemic when bubble zones were incorporated around hospitals and schools. It then widened to include libraries in Calgary, even public sidewalks in front of libraries. In Calgary, it was a response to protests about drag performances for kids in libraries. And Calgary actually banned what they call specified protests within 100 meters, so way bigger, twice the size of the bubble zones for abortion clinics. And in Calgary, the protests that are prohibited are ones that express objection or disapproval towards an idea related to some human rights grounds, which really allows officials to punish speech on the basis of very particular topics. This has now reached what I think is a crisis point. In 2024 and 2025, municipalities began passing these rapidly. We now have bubble zone laws in Ontario, in Vaughan, Toronto, Oakville, and Brampton, creating these sweeping bans near schools, places of worship, and other, quote, vulnerable infrastructure, some with fines as high as $10,000. And they don't just restrict illegal activity, they criminalize even lone individuals for expressing disapproval, even if that disapproval might be silent. So the Carney government has proposed taking this even further. During the campaign, they promised to create federal bubble zone laws using criminal law, and the current Justice Minister federal has talked about moving forward with that commitment. And this is a problem across the political spectrum because conservative MP Jamil Javani has now proposed that the Heritage Committee study creating bubble zones. This is all, a terrible idea. The risk to civil liberties by bubble zones is profound. Once governments are allowed to pick what ideas can be heard and where they may be spoken, freedom of expression becomes a permission instead of an actual right. And these are politically motivated targeting of disfavored views. And history shows that restrictions justified as protections for the vulnerable are often turned against them when the political winds shift. So that's why we need to consistently defend our civil liberties, even when the speech is uncomfortable, offensive, or unpopular. And it really, you can see this playing out right now in this Sean Feucht controversy. If you like Sean Feucht, you might not this controversial singer, this Christian worship singer who has socially conservative views that he's expressed online. There's this controversy around his permits being pulled. Well, if you like Sean Feucht, you might not like that people are protesting in front of a church where he's performing, but that is how democracies work. Instead of canceling and pulling Sean Feucht's permits, or the permits of other controversial speakers or singers, we should counter their speech with other speech. So likewise, if a controversial imam wants to go on tour preaching things that we disagree with, we should be allowed to protest. This is actually playing out right now. Right, I saw today that a group called the Islamic Relief Canada is sending someone on tour across the country. Islamic Relief Canada has a parent organization called Islamic Relief Worldwide that a lot of people are concerned about because of what they say is anti-Semitism within that organization. In fact, in 2020, the US government sent out a press release condemning the statements of Islamic Relief Worldwide's leadership. So the fact that one of their branches, Islamic Relief Canada, is sending a speaker around Canada, if he's speaking at mosques, people might want to protest that, and they should be allowed to, just as people should be allowed to protest in front of a church if they disagree with Sean Feucht singing inside. But the bubble zone concept shuts down that whole discussion. So, I think that the Sean Feucht issue has been beaten to death. If you want to learn more about it, I have a paper coming out in the Hub, an article coming out in the Hub about that, where I compare his situation to a really famous situation in Canadian constitutional law. Josh, if you want to talk about that or about any of the things I've talked about on bubble zone laws, I know you have a lot of thoughts on this.
Yeah, I think the comparison to that famous case, which is Roncarelli and Duplessis, is really apt because what happened there, this was in the 1940s when Quebec was a very Catholic province where the government was also essentially had a state religion, which is Catholicism. And Duplessis was both the premier and also the attorney general. And Roncorelli was a Jehovah's Witness, and he had some money because he had a restaurant, and so he would go and bail out Jehovah's Witnesses who would be fined and put in jail for proselytizing their particular religion, which was verboten in Quebec at the time. And to get back at Roncorelli, the premier decided he was just going to pull the liquor license from the restaurant. Well, the Supreme Court said you can't do that. There's no absolute or untrammeled discretion in administrative decisions like that. And that stands for the idea that you can't shut down people because of their political views. You know, freedom of speech, we didn't have a charter back then. We had some protection for freedom of speech. But in this particular case, that clearly this was discrimination on the basis of the speech and on the religion. And the Supreme Court said you can't do that. So it's funny that politicians in 2025 still haven't learned that lesson from, 1946. But hopefully they learn it this time. I'm not so sure that they will. I just saw today that Winnipeg is also banning a concert in a public park by Sean Foyt, and they specifically said it's because of what he might say. Absolutely ridiculous. Anyway, that's all I want to say about that. Joanna, what do you think?
I don't have much to add. I think everyone should read Christine's paper, although I was disappointed. She wanted it to be called Pop the Bubble, and I noticed that they called it Burst the Bubble. I think Pop the Bubble was better. But
I
anyways,
think so
it's a
too.
really good
Oh wow.
paper. And I commend it to you, and it's never been more timely, and it's never been more important to have a principled position on all of this. So let's take a break, and when we come back, we'll talk about Hockey Canada and get into some bad legal takes. Okay, so as pretty much everyone knows, and one thing that was interesting about this Hockey Canada verdict is that it really got a lot of international attention. I guess because it kind of fits into the broader Me Too slash post Me Too zeitgeist, or maybe just the story of elite sports and unsavory sexual facts was just too much to resist. So, of course, Justice Maria Caracia delivered a verdict of not guilty and acquitted all five accused: Michael McLeod, Carter Hart, Alex Formanton, Dylan Dubé, and Callan Foote. They were all found not guilty on all counts of sexual assault. So first, I'm going to go through some of the major findings of her decision, and then I'll share a little bit of commentary. So Justice Caracia found that there were major issues with the complainant EM's evidence. She found there were credibility concerns. She had inconsistent testimony. She often answered questions by repeating previous statements rather than telling the truth. She referred to, quote unquote, her truth rather than the truth. She filled memory gaps with assumptions, which she acknowledged rather than actual recollections as best as she could. A lot of her evidence was contradicted by video evidence. So, for example, surveillance footage from Jack's bar in London, where she met Michael McLeod and the other team members, contradicted several of her claims, particularly about her level of intoxication and who purchased drinks. So it was found she was buying Jaeger bombs for herself, for McLeod, and she had said, they were trying to liquor her up. And there's video evidence that shows that's not the case. Some of the key inconsistencies the judge found: EM never mentioned being scared or fearful in 2018 police statements. She first raised the issue of fear in her 2022 civil lawsuit. Her intoxication levels, video evidence showed that she was not obviously impaired. She walked steadily in high heels. She handled money transactions. She appeared coherent. And there were initial statements indicating from EM indicating she consented to the sexual activity. In August 2018, she told the cops she believed the sexual activity was all okay in her mind at the time. So going on to the court's findings on consent, which was, of course, the major issue of this whole affair. It's fairly clear that sexual activity happened. It's not a question of denial of the basic facts. So it really turned on, did she consent to the sexual activity? And in this case, and I'll have some comments on this because this is really unusual and this surprised me. I clerked for the Court of Appeal for a criminal judge. I worked in criminal law. I must have read like close to 1,000 sexual assault decisions, many of them acquittals, and I've never read a judge finding actual positive consent, I don't think. In this case, Justice Karatsia concluded that EM did express that she wanted to engage in sexual activity by the men by saying things like, is somebody going to bleat me and masturbating in front of all of them? And she found actual consent not vitiated by fear. Some evidence that supported that the activity was consensual. There were multiple witnesses that testified that EM was asking men to have sex with her. There were the very controversial consent videos where EM clearly stated the activity was consensual. She appeared coherent and unimpaired. And there was consistency across the several witnesses called of EM initiating and requesting sexual activity. Again, the judge rejected the argument of fear-based vitiation of consent. She found there was no threats, there was no physical force. EM had multiple opportunities to leave, but she chose to remain, and there was no evidence at all that anyone prevented her from leaving the room. So in the result, Justice Karatsia stated, I have found actual consent not vitiated by fear. Okay, so what are my thoughts about this? Okay, so first of all, I wrote an op-ed about this in the Hub where I started with a personal story that some people reached out to me and they were like, it was brave of you to share this. But to be honest, I don't think there's a woman in the world who doesn't know what I'm talking about. And I talked about what I know to be the fawn response, which is another fear response, in addition to, like, we've heard of fight, flight, or freeze. For women, there's a common trauma response called fawn, which is when you're in a situation, usually with somebody who's physically stronger than you, not necessarily a sexual situation, we have an impulse to kind of smile and go along with this. And I have experienced this in my early 20s. I was, taken to a secluded spot on the beach by a stranger who had been buying me drinks, and things happened. And at the time, I clearly remember, if I don't go along with this, something ugly is going to happen. So it's better to just go along with it and it'll be over. And of course, I felt horrible afterwards. But I know that psychological switch that's in my mind. I was surprised to discover it. And so what I understand from this is that, yes, fear can look indistinguishable from enthusiastic consent. And of course, I didn't make any allegations against the individual afterwards. I understood it was more complex than that. But that does sort of add some shades of moral complexity to this Hockey Canada case. And I acknowledge that when you read what happened that night, nobody should be proud of themselves. The acquittal feels uncomfortable. The courtroom dynamics were difficult to witness. You have this woman being, aggressively cross-examined by 5 sets of counsel. So counsel for all 5 of the 5 accused. But it's important to remember that this is a criminal trial. It is not a symposium on sexual morality. It's not a symposium on trauma psychology or on the norms of proper gender relations that we should aspire to. It's a process very specifically bound by high thresholds of presumption of innocence. So again, here, the complainant testified that she was too frightened and intimidated to truly consent and that she was coerced by circumstances. But in order to get a factual picture and build a factual record that can justify an acquittal or a conviction, you have to look at all of the objective evidence and look at what are the reasonable inferences. So being recorded twice, agreeing, discussing specific sexual acts and participating willingly in those sexual acts, exaggerating at some point her level of intoxications. And EM's response to all of this is that she was adopting a porn star persona to keep herself safe. And again, that has a ring of truth to me. But the legal reality is, even if you had fully accepted that and accepted it on its terms, which I thought, to be honest, the judge would do more lip service to it. Again, I just haven't seen this, and I have a theory about why the judge was so harsh here, which I'll get into in a moment. But even if the judge had fully accepted everything EM said, I was just acting out of fear, I was adopting a persona, they still probably would have been acquitted, these 5 hockey players, because the Crown had to further prove that the accused couldn't have formed an honest but mistaken belief in consent, which is a defense that asks, could a reasonable person in this situation believe that consent was communicated? And there's a landmark decision on this called Ewanchuk, which was a 17-year-old girl who was invited into a van, and the man in the van started making advances on her, and she didn't physically move away, but she did say no a few times. And initially, the judge in that case, in the early 90s, found, well, that's honest but mistaken belief in consent. That was overturned, and properly so, right? This is a very different case, though, right? For all of the reasons that I've gone through, I think, twice now. So here's my theory about why the judge in this case was so harsh in some sense and unusually definitive. From what I read in interviews with the Women's Legal Education Fund, even some of the Crowns about what was up in this case, they were essentially pushing a new evolution in the law of sexual consent. And this is building on a case from, I remember I wrote an op-ed about it in the Montreal Gazette when it came out when I was just finishing law school. So it would have been around 2013, a case called J.A. And this is the infamous sleeping spouse case where, to be really brief, there was a married couple, and the married couple had certain proclivities. And in this case, the woman asked the man, I want you to knock me unconscious, and then I want you to perform whatever XYZ acts on me while I'm unconscious. And the evidence was this was not the first time they had done it. So the husband did these things. Then later, there's a custody dispute. And in the context of the custody dispute, the woman makes an allegation of sexual assault because he sexually touched her while she was unconscious. Now, pretty shockingly, the Supreme Court finds, yes, even if you agreed to everything that he did while you were in advance, sexual consent requires ongoing, contemporaneous consent. You cannot consent in advance. And there's a lacerating dissent to this by Justice Fish, which I highly recommend, where he basically points out, at all times, the complainant's mind was a consenting mind. So this makes no sense. But I spoke to a Supreme Court judge about this while I was interviewing at the court, actually. And I'm not going to say who the judge was, but I remember the judge says, yeah, I read your op-ed, but I think we were really worried about the girl who passed out drunk on a couch at a house party. And we basically wanted to do this for policy reasons, that you should just assume that an unconscious woman cannot consent. Whatever you want to make of this. So you can see how the Crown wants to draw a further line and say, not only does consent need to be active, contemporaneous, and ongoing, you need to take specific steps, depending on the circumstances, to ascertain affirmative consent. And in this case, I think they said, one of these guys should have taken her to the side. They should have figured out what was going on. And this is a very difficult proposition to sustain in the criminal law. I think Megan Savard, lawyer for one of the accused, said, these are adults that were discussing specific sexual acts, requesting sexual acts between them. How could this not be consent, particularly in the context of the criminal law, which requires proof beyond a reasonable doubt? So I've been going on a long time. I guess to wrap this up, one point that I think is really important to drive home is that however you feel about this, and it's very rightful to have complex feelings about it, we'll see what happens with these guys' careers, but the criminal law is not a tool to remedy our cultural problems, to enforce or moral aspirations. It's a shield to ensure that no one loses their liberty without the very clearly established threshold of guilt beyond a reasonable doubt. Josh, Christine, anything you want to add?
Yeah,
Can I jump in
you go ahead,
first,
Josh.
Christine? Just before I forget what I'm thinking, you made a really good point about how not a lot of people come off looking very good here, even though, these young men were acquitted. I think a couple more people that or groups that don't come off well that we should talk about are first of all the media and now the NHL, because the media, I think, is the reason that we ended up having this criminal trial, even though there probably wasn't the evidence there to begin with. And it's a really serious thing to charge people with a crime. You take away years of their life, it costs them tons of money. And in this case, it might have cost these men their careers, right? But the media just seemed to have this narrative that the police were, being unfair to the women by saying, or the woman involved saying that this was unfounded, when really there's every reason to believe they just didn't think the evidence was there. And then so they reinvestigated with a different detective, and after this media outcry, what a surprise, suddenly they find there is enough evidence there to charge, and that it would be in the public interest to do so. And so the media holds some culpability for like forcing these young men to go through this, even though obviously, like I say, they also don't come out looking good because of things that happened in the hotel room and that shouldn't have happened and that they could have stopped, right? So that's bad. And then the NHL, like there's still an open question whether they'll be allowed to play hockey. And I think if you're not guilty of something, then I can't see why you would be kept out of the league. So anyway, that's all I wanted to say. Christine, what were you going to
Uh,
say?
I think that the NHL did put out a statement. They said that even though the men had been acquitted and the allegations found not to be criminal, they were disturbed and that the behavior was unacceptable. So I think that they have said that they're ineligible for return while under review, and I think that they're still under review right now. Another one I'd add to the list of who doesn't look good is Hockey Canada, obviously, for using the league fees for junior hockey players' ice time to pay for civil settlements and sexual assault or sexual misconduct claims, because that's what happened. That's how this all came to light. Was that there was a disclosure that there had been a large payoff to EM in a civil settlement. I think Joanna's point is so excellent that the criminal law is not the right place to hash out cultural disputes about consent and the complexities of consent, but it is important that we do that as a society, because I think it's important to educate young men about what is good conduct.
And
um,
young women.
and young
If you
women.
walk
Yeah,
into a hotel room and there's 9 guys there and you're the only girl, get the hell out.
yeah, I mean, I have a son, and I really want to emphasize how important it is for him to act respectfully. When I was thinking about the men in my life, I just don't know men who would act this way, really. Like my husband would never act this way.
You don't know any men who would act this way?
Okay,
Okay.
I know some
I
who might engage in disgusting sexual conduct, but um, the men that I love and who are I'm close to, would never behave this way. And I think it's important as a culture to raise up good men who would. There were some men who were invited into that room. They saw what was happening and they left. And
yeah.
that's the type of son that I want to have. And I think it's really important as a culture to discuss um, how important it is to treat women respectfully and with dignity, because that did not happen in that room, even if the judge found that there was consent. Um, there's a totally different cultural issue at play here.
Yeah, by the way, I just need to close the loop on I got so carried away talking about JA, just to bring it around. I think the judge must have been aware of what the Crown was trying to do with this new theory of like new requirements for consent. And I think part of why she was so harsh was signaling to them, like, don't try this, like just shut it down as clearly and cleanly as possible. But that's just my theory. Who knows?
Yeah, I think you're right. Let me turn now to our bad legal takes because I've got a bunch. I've got a bunch of bangers this week, all related to Sean Foyt. So I think everyone, if you're listening to this, you probably know about the Sean Foyt controversy. I alluded to it earlier. Basically, this socially conservative Christian worship singer was invited to play or came to Canada to go on tour. He had his park permits revoked from some public parks or not issued for some public parks. And then he was invited last minute to sing at a church in Montreal. The Montreal police barged into the church and they gave the church a $2,500 fine for, they say, not having a special event permit, even though, it was ordinary use of the church. They shouldn't have to get a permit for that. I don't think they would be required to. And there's a lawsuit now about this fine. So here are a few comments that we saw on the worst smug left wing or like this is how you behave proper liberal types on boomer Twitter. So we have this one woman, Deirdre Mitchell McLean, said, this is a classic, okay? This is a classic tweet I see all the time, and it's just so wrong. So Deirdre said, we don't have free speech in this country. We have freedom of expression subject to reasonable limitations. So the reasonable limit part is true. That's section 1 of the charter. But we do have free speech. As I've said many times before, freedom of expression is the guarantee, and freedom of expression includes speech. It's actually a broader protection. The next one that made me really irritated, because this one was all wrong, was Noelle, who has a lot of followers on X somehow with all of these really bad takes. She said, just a quick FYI, hosting a concert isn't a charter right. Also, charter rights don't apply to Americans with criminal records. So actually, that is wrong across the board. The Canadian Constitution guarantees the right to freedom of expression and freedom of religion. And a concert taking place inside of a church, a worship singing performance inside a church is both expression and religion. So yes, having a concert is an expression of your charter right. Also, on her comment that the charter doesn't apply to Americans with criminal records, this charter guarantee applies to everyone in Canada, which includes Americans. And it's interesting to me that suddenly the left is arguing that foreign nationals in Canada don't have charter rights, because that would typically be an extreme right-wing position that is legally wrong. And it would, have big implications if foreign nationals inside Canada didn't have charter rights. They do. It also doesn't matter that Sean Foyt has a criminal record. By the way, his crime was shooting a wild turkey on his own property without a permit, which I guess you can be criminally charged for that, but it would not have any effect on your ability to enter Canada. I also think the reporting was that he got a fine for having weeds on his property. So, very dangerous individual that suddenly the left doesn't want allowed into our country. And then the last one, there were a lot, but so I'm sorry I have such a long bad legal take, but there were so many on this issue, was Ed Hand said my analysis that the municipality in Montreal was wrong to say that a permit was required for this worship service inside the church, which is an ordinary use of the church. He said, oh, and what other municipal laws will you challenge? If it was against the charter, it wouldn't have passed. So apparently, it's news to me that municipalities just don't pass laws that violate the charter. Suing different levels of government, including municipalities, for doing unconstitutional things is literally what we do with the Canadian Constitution Foundation. Governments pass unconstitutional laws all the time. Newsflash to Ed Hand. Yes, governments do things that violate our Constitution. That's why we have organizations like the CCF to fight back. So, Josh, how about you? What are your bad legal takes?
My bad legal take, and I only have one, unlike you, Christine, although I'm glad you did all of those. It goes to an Ontario court that sentenced a really dangerous person to just 60 days of house arrest instead of a real prison sentence for his very disturbing threats to the Jewish community. I'm talking about a man named Waisadin Akbari, who's an Afghan immigrant who told a car dealership employee that he didn't want to finance his car because the interest payments would go to Jewish people. And according to the court decision, he equated Israelis and Jews with cockroaches who should be exterminated. Is pretty harsh criticism there of the Jewish people. He also talked about how Jews control the world, which is a common anti-Semitic conspiracy theory. And most chillingly, he said, "Before I go, I want you to remember my name and remember my face because next time you see it, I'll be on the news. I know when I'm going to die because I'm going to plant a bomb in every synagogue in Toronto and blow them up and kill as many Jews as possible." So the salesperson, who the judge notes was of Pakistani Muslim descent, was so alarmed that he asked, are you serious? And this guy, Akbari, responded, "Yes, I'm serious. I'll make sure those attacks are filmed and posted online so the world can see what I've done." So this is about as scary and dangerous and imminent of a threat as it gets, except not naming the particular, synagogue, although he did say all of them. But the judge notes that the threats were not backed up by evidence of weapons, explosives, maps, planning, or coordination. So his guilt is just based on empty threats that he communicated to a stranger. The judge also notes that hate-based threats are not just words, they're gasoline upon which even more serious offenses burn. And when hate is normalized, harm follows, and he goes through the harm this has caused to the Jewish community. But then the judge finds that there are all kinds of other mitigating factors, including that Akbari's father died when he was 4, that he fled the war in Afghanistan, that he lost large sums of money in gambling, and that after the media coverage of these charges, he lost his restaurant franchise for a shawarma shop and now he's broke. And so the judge then went through the previous case law and he noted that 2 months ago in the same jurisdiction, a man who spat at Jews while glorifying Hitler was given a 12-month jail sentence. So for some reason, Akbari's threats, which to me seem a lot more serious with all those mitigating factors, despite the extreme nature of the threats, was only worth 60 days of house arrest. I just don't think that's sufficient. I don't think that sends the right message that if you make these really serious, specific threats in public, that you should just get 60 days of house arrest. So that's my bad legal take of the week. Joanna, let's hear yours.
So my bad legal take goes to Toronto Star columnist Heather Malik, who asks, apparently earnestly, why female lawyers would deign to represent men accused of crimes. This isn't just a bad legal take, it's a very regressive and philosophically confused one. Par for the course for Ms. Malik.
It's also really sexist.
It's super sexist. So in an adversarial justice system, the right to full answer in defense is well established and sacred, and defense counsel does not endorse the conduct of the accused. They ensure that the state meets its burden of proof. And if that principle makes you queasy, you have a medieval opinion, not a legal one. But she's not really trying to argue law. She's trafficking in gender essentialism. She's suggesting that women, by virtue of our sex, should be emotionally or morally disqualified from defending men accused of crimes, as if the role of a lawyer is to mirror the accuser's pain rather than uphold the structure of a just and ordered society. And also as if empathy and due process are incompatible. And worse, she implies that women who do defend such clients are either complicit in misogyny or serving as props for the accused. She uses the phrase skirts to hide behind. That's deeply insulting to female lawyers. It's infantilizing, and it reduces professional women to symbols and not agents with free will. So Heather Malik, defending the presumption of innocence doesn't make you a gender traitor. We've heard this argument many times before. It makes you a lawyer, and suggesting otherwise is not feminist. It's essentialist drivel in a progressive costume.
All right, well, that's the show. And as usual, we hope that you'll go and rate us, review us, and subscribe if you haven't already. And you can support our work by subscribing to the CCF's YouTube channel, by following us on X, or by visiting our website, theccf.ca, where you can sign up for our Freedom Update newsletter. The Canadian Constitution Foundation is a nonpartisan legal charity funded by your donations, so please do click that donate button on our website if you can. Thanks for listening.